Hi, I'm Caitlin Jenkins, the family law blogger, and today on the blog it's the 6th of July and I'm delighted to be joined by John West, who is from SKO Family Law Specialists in Scotland, and we're going to talk about a case that was reported, the judgment was reported and handed down by the Supreme Court in England at the end of last week. And John's firm were involved in this case, and it's the case of Villiers, and the reference to the case will be in the notes at the bottom of this blog. So this case is a really interesting case. It's about the interaction between the law in England and Wales, family law in England and Wales, and that in Scotland. And I suppose the first thing to flag is that England and Wales are seen as one jurisdiction, and Scotland is a totally different jurisdiction for family law purposes. And quite often, I'm sure John would agree, our clients are quite surprised about that. So it's a different jurisdiction. There's really different law that applies in relation to family law in Scotland to that which applies in England. And sometimes, as in this case, that can create quite a sort of conflict of who should be dealing with which aspects of the case. And also different terminology, which John and I may pick up a bit as we go through. So, John, first of all, welcome to the blog and thank you for discussing this case. We're really grateful. So tell me a bit about the sort of background. From recollection, these parties were married for quite a long time. They lived most of their married life in Scotland. They separated, and I think it was the wife who came back to England. So husband was left in Scotland, wife was in England, and then the divorce proceedings started. So can you tell us the basics? What happened initially?
Yeah, that's right. Thank you very much, Caitlin, for having me as well. So what happened after the wife had returned to England and Wales was she issued a divorce petition in England in 2013. And that was then followed by the husband issuing, or lodging as we would say in Scotland, an application for divorce in Scotland in 2014. Now, because of the way the legislation works between Scotland and England and Wales, and Northern Ireland, the place that would be able to take the divorce, because there was two competing divorce actions, was Scotland, because that's the place they'd last lived together as a couple. So in 2015, the wife, she consented to her divorce action in England being dismissed, and that meant that the Scottish divorce action could proceed. But what she also did was make an application under Section 27 of, I think, your Matrimonial Causes Act, 1973.
Yep, 1973 Act.
For maintenance. What then happened was that the husband applied to the court in England to have the wife's application for maintenance stayed on the basis that the English court shouldn't exercise its jurisdiction because divorce should be taking place in Scotland.
So you had the two different jurisdictions then. So you had Scotland, the wife agreeing that Scotland could deal with the divorce bit. And then basically the roundabout was where would the financial bit be dealt with, because the wife had issued this application, as you say, under Section 27 for maintenance in England.
Exactly, a standalone maintenance application. And what the English High Court said was, no, it's okay for maintenance to proceed in England and divorce to proceed in Scotland, and so ordered that he pay maintenance to the wife. And this is all about because of how an EU regulation, the maintenance regulation, has been applied within the UK. So it treats Scotland and England and Wales as if they were separate member states for the purpose of maintenance, which we might come on to discuss a little bit more in a minute. What then happened was the husband appealed to the Court of Appeal, but he was unsuccessful there. So he took it to the Supreme Court, and that was the decision that was made last week. We're on a split majority, so 3 of the judges out of the 5 decided that the husband's appeal should again be refused, and that's us up to present day.
So the Supreme Court last week were basically saying, so yes, the divorce bit can be dealt with in Scotland and has to be dealt with in Scotland, but yes, the wife can have the maintenance bit dealt with in England, and that can carry on, even though that seems, on a sort of common sense approach, seems quite a sort of strange circumstance to have. So so that's what the Supreme Court said last week, so presumably that's what's going to happen in relation to that case. Couple of observations, I suppose, for those who aren't involved in the courts that often. One of the things that jumped out to me when we were discussing it before as well is, you know, these the original proceedings in England and in Scotland were 2013 and 2014. We're now 2020. These things take a long time to sort out in both courts. And the Supreme Court looked at this actually in December 2019, and then the judgment was last week. So, and that's 6 months for that bit of the judgment. So when you're in these sorts of problems, these sort of situations where you've got England and Scotland, or indeed other jurisdictions, as you and I both deal with, it can take a long time to get these things sorted out, can't it?
Absolutely. And I think two interesting points just to note there. You've already mentioned that English law and Scots law are very different, and with maintenance they are potentially on different planets of how different they are in outcome. We in Scotland are regarded as potentially being what you might say tight to maintenance creditors, those that are applying for maintenance, whereas in England regarded as being quite generous, and that's why that was really important. The other thing to say was that the Scottish divorce action through all this time was sisted. Now that's just our Scottish language for stayed, so the parties haven't actually been divorced. They are still married whilst there has been all these proceedings taking place in England and Wales.
And that's a long time to stay married whilst these are sorted out. And you're absolutely right on the maintenance side. And we're talking about an English case and a Scottish case, but this situation arises quite a lot about where divorces should take place, whether it's Scotland, England, or somewhere else across the world. And the question of where financially might be the better circumstance for somebody to get divorced is often one of the driving factors in that decision making. And England, if Scotland might be regarded as tight on maintenance, maybe, to use your word, in England tends to be regarded as generous, or as some people would say overly generous on the maintenance side of things. And that because we have a totally different, very discretionary system that takes account of different factors. So our jurisdictions are coming at maintenance from different angles, really. And so you're absolutely right. In this case and in other cases that we all look at, often what the finance isn't just about where people could get divorced or where their finances could be sorted out. It's about where is most likely to be most advantageous, often based around the generosity or otherwise of maintenance. Mm-hmm. So if that's the case for these two parties, what do you think the broader application could be between cases between England and Scotland? Where do you think it sort of leaves us in those discussions?
What was really interesting about the decision by the Supreme Court, or one of the interesting aspects, the nub of it, was that they said that the wife's maintenance application wasn't related to the Scottish divorce. And there's quite a lot of technical EU law issues that were brought out through the judgment. But what they effectively said was that we're not related actions. So you could have your maintenance application proceed in England and your Scottish divorce proceed in Scotland. And there's a nice word for that. You've got the bifurcation of proceedings, having them to separated out, which is quite interesting. Now, what they said was they were okay, the Supreme Court was okay about maintenance creditors, the person that's seeking maintenance, choosing the best forum, the best place, the best court for their maintenance applications. And they are allowing for forum selection, I suppose, rather than forum shopping, which can sometimes has quite negative connotations. And one of the judges, what they said in that judgment in the Supreme Court was that the maintenance creditor has an unfettered choice and is entitled to bring their claim in the English court, in this case, on the grounds that it is convenient, but also because that person believes it will be more advantageous to them. So the practical issues that I think arise from that, because as we're saying, maintenance is usually more generous in England than in Scotland, I think one practical aspect will be that there are more people looking to see whether they can make a claim for maintenance in England rather than dealing with it in Scotland. And if that's the case, they may feel, even if the Scottish courts would be the place that should deal with the divorce, that actually the parties think the English court should just deal with it all. So there might be more divorce and maintenance traffic going to the English courts rather than the Scottish ones.
Yes, I can see that, and I think it is the logical conclusion of what happened here. Do you think it'll happen the other way? Do you think there'll be more, what do you call them, maintenance debtors, the payer? Do you think they're likely to try and shop the other way, to use the terminology, or do you think that's less likely?
I think it's a really good question, and I think it's one that has been being thought about ever since the maintenance regulation, this European law, came into force in the UK in 2011, about whether you could, as a maintenance debtor, do something cunning, do something clever to seize jurisdiction for maintenance in a jurisdiction that was more favourable to you, so you might be paying less. And what the Supreme Court seemed to be saying is that that isn't something that they would support, and they are effectively following through the spirit of the maintenance regulation, which is to say it's all designed in favour of the maintenance creditor. It's them to choose, not the debtor. So I think what that does is restricts maintenance debtors' options, but it also potentially restricts the importance of seizing jurisdiction by the maintenance creditor, because how the system is designed is whoever gets to court first wins, and that's the place that would deal with the maintenance. But if it's only about where the maintenance creditor can go and it's up to them to choose, then I think it limits the whole race to raise issue. But having said that, taking legal advice on these cross-border issues is always really important.
Absolutely, and also in a timely way, whether you're the maintenance creditor or the maintenance debtor, the who issues first and where and about what, if this case particularly is highlighted about what, whether it's just about a divorce or about finance, is really, really important. Absolutely. And you mentioned the maintenance regulation, which is an EU regulation. Where do you think, or is one of the things we need to be thinking about going forward, what do we think is going to be the relevance of Brexit and the changes coming up at the end of this year to this sort of case or this sort of scenario? Or is the answer is we just don't know yet? I
think yes. I think the answer is watch the space. We don't know what arrangements will be in place following the end of the transition period, which we think is going to be the end of this year. There doesn't seem to be any change to that. What that means for not only cases involving UK parties with other EU member states, so your England and your France, or your Scotland and your Germany, but also this legislation, the way it's been applied within the UK, because it comes from an EU regulation. What does that mean for our Scottish English, Scottish Northern Irish cases? That all has to be decided. So it's a case of keeping an eye on it and making sure that you are taking legal advice from specialists, those that are dealing with these sorts of cases, as soon as possible.
Absolutely. And John, I always say at the end of these vlogs that the information and discussion that we have, or I hand over in a family law vlog, can only ever be very general. And I always say to people, if you have a family law issue that people need specialists, you need specialist advice on. You can't just take the general information from our discussion, because as this vlog highlights, the situation between England and Scotland is very nuanced. It's not necessarily what people would expect. And the Villiers case has just highlighted quite how technical and complex that is, and also how important for the actual financial outcome for the family it can be to have all of those issues looked at, and potentially looked at quickly. So if you have a family law situation that has an English or a Scottish or a dimension or any other jurisdiction, then you should take specialist advice. As I say, my details and those of John at SKO Family Law Specialists will be in the notes to this blog. But in the meantime, John, thank you ever so much. That was really helpful. And it was always great to talk to you about these technical things that overlap between England and Scotland. Thank you.
Thank you, Caitlin.